All right, well, attorney Wendy Brewster Maroun specializes in representing unit owners with regard to the condo and HOA associations. And take it away, Wendy.
Thank you, Alex. It is my pleasure to be with you all today. I do a lot of work in the area of association litigation in particular, but I wanted to create a presentation for this specific group that would be relevant to the issues that you're likely to deal with as you invest in properties that are located within residential communities. Associations are really about a common form of community living. And there are a number of areas in which it impacts the law, whether it's contracts, real property, and even civil rights. Believe it or not, there are a number of claims that people present on the basis of a violation of individual civil rights through things such as discrimination claims, age claims, just a variety of things. So Americans with Disability Act claims, there are a bunch of things that fall within what we call association law. I focus mainly on the breach of contract piece, and the contract, just so everyone is aware, is the association's governing document. And usually, more specifically, when we talk about that, we're talking about the Declaration of Restrictions and Covenants or the Declaration of Condominium. There are primarily two statutes that cover any issues that you as investors might deal with under the Association Acts. One we refer to as the Condominium Association Act, which is 718, Chapter 718 of Florida statutes. The Homeowners Association Act is found primarily under Chapter 720 Florida statutes. Just to be clear, the Homeowners Association Act only applies to residential communities. It excludes commercial or industrial properties in mixed residential and commercial communities. As for the Condominium Act, every condominium is subject to the act. And whenever you purchase a property in either a homeowners association or a condominium association, you automatically become a member of that association. One of the things that everyone should be aware of, and I'm sure this group is aware of, there are primarily three governing documents that control what happens: the rights and the responsibilities, the benefits and the burdens associated with this form of home ownership. Those documents, and I'm just going to go over them briefly because we're limited by time, and actually have arbitration set at 2 o'clock today, so I have to be done by 1. But the governing documents that you will primarily deal with are the Declaration, which I mentioned, the bylaws, and the Articles of Incorporation. The bylaws are the sort of corporate rituals or the internal governance of the association. Those dictate how the board of directors will act. The Articles of Incorporation create the entity as a recognized business entity in the state of Florida. The Declaration, which I believe in working in this area, is really, really the document that attorneys who do association law generally refer to as the Constitution. I mean, this is what really dictates what the rights and responsibilities are of owners and the associations in these particular communities. So whenever I get a case, the first thing I do is request a copy of the Declaration of Covenants and Restrictions or a Declaration of Condominium, because that's going to tell me what sections of the relevant statutes apply to whatever issue we're dealing with. Once you get, and everyone upon purchasing property in these sorts of communities, as communities with associations, I don't do the transactional piece, Alex does that, but it's my understanding that as a part of any closing, you're supposed to receive and or provide a copy of these documents to the new owner or receive them from the prior owner. And it's very, very important. I have a case right now where my client purchased vacant land in a community with an association, and he purchased the land in 1991, never really took a close look at the governing documents because, you know, it's just vacant land at this point. Well, he goes to build on the land in 2017, and little did he know there's a covenant within this community where you have to complete all construction within 9 months. Well, this community, these lots are pretty big. I mean, they're at least an acre large. He's building a 10,000 square foot home, and under no circumstances would he be able to complete construction within 9 months. So that's a problem. And I always tell investors, primarily are the individuals who I represent, you've got to look at these documents. And if you don't have the time to look at them, you need to hire an attorney to look at them, because there are provisions in there that you may be bound to follow. And so if you have plans on building, you know, your dream home, and it's, you know, along the lines of the Taj Mahal, well, guess where you shouldn't purchase land or purchase property? In a community with a restrictive covenant that says all construction must be completed in 9 months. So it's just very, very important that you review whenever you purchase property or contemplate purchasing property within a community with an association, that you take a look at those provisions or have someone who you trust and who has the legal expertise to take a look at those provisions and let you know exactly what you're getting yourself into. Because these rules are in place because people who purchase property in these communities have an expectation that they're going to have a certain quality of life and that they're going to be bound by certain rules and regulations. And as a newcomer, you are agreeing by virtue of purchasing property in these communities to be bound by those rules and regulations as well. In addition to the declaration, the articles of incorporation, and the bylaws, you also sometimes find rules and regulations, and those are promulgated typically by the board of directors about, you know, simple things such as, you know, what you can have on the outside of your property. For some reason, when within the past few years, whether you can put a basketball hoop in front of your property was a big thing. I know it was something that became an issue in my community, but you also want to take a look at the rules and regulations so that it's clear the board of directors for these associations are in a fiduciary relationship with its members, meaning they have an obligation to look out for the best interests, typically financial, of the members of the association. So one, that's sort of the documents that we as attorneys look to figure things out in terms of the rights and responsibilities of the various parties. Parties would be the association or the owners of a unit or a single family home or residence within these communities. But then once you actually get into the property and an issue arises, and as investors, you know, I represent an investor who purchases a lot of properties through foreclosure. And within a matter of days of purchasing the property, they're getting notices from the association because the prior owner didn't keep up the property. There are repairs that need to be made to the property. Well, who's responsible for making those repairs will also be found in the governing documents in your declaration. But that's something that I would imagine as investors, you probably get notice of as you're purchasing properties, that associations are putting pressure on folks to make certain repairs and to bring the property up to whatever the standard is within the community. If you cannot agree on certain types of disputes, then what happens typically is for the homeowners association, you have to go to, or the association, I should say, will request, make a statutory demand that you participate in mediation. This is a tricky area. One of the things that, and one of the reasons why I wanted to touch upon this is because this is an area where people get tripped up with the rules. And we all think, oh, I can kind of muddle my way through this, but there are some very, very strict procedures about how you respond to an association's demand for pre-suit mediation. And I just want to touch on that briefly, because similar to what happens in the landlord-tenant context, where if you do not send the notice to the tenant advising them of any claim that you may make against their deposit, you're automatically in hot water, right? And that notice has to be sent certified mail, return receipt. Well, similarly, in the pre-suit mediation context for association disputes, and I'm talking now specifically about homeowners association disputes, which fall under Florida Statute 720.311, the entire process is very, very heavily and strictly scrutinized. So the statutory demand has to be sent to you as a homeowner or an investor, whatever address you have on file, via certified mail return receipt, along with a copy sent via regular first-class U.S. mail. You then have 20 days, and this is statutory, 20 days to respond to the statutory demand to participate in pre-suit mediation. And you have to send your response via certified mail return receipt, and you also have to send it first-class mail to the address from the address on the letter that you received demanding pre-suit mediation. So just be very, very careful when you get these demands, if you have received them or if you ever have a dispute with an association, that you are responding the way that the statute requires you to respond. That is one of the easiest pitfalls that I see folks make. And I will tell you, I have an issue right now that's up on appeal where the client, who was the owner investor, responded to the association statutory demand for mediation via facsimile. Now, whether the court will ultimately decide that there was substantial compliance on the part of the homeowner, we don't know yet. I will say that the association received the response and tried to coordinate mediation. So there's an issue as to whether or not they waived strict compliance with the statute or not, but that is an issue that we'll soon find out once a decision is rendered, whether or not and how exactly the appellate courts are going to interpret that requirement. Parties must participate in the entire pre-suit mediation process. And why is that important? It's important because at the end of the day, if the association files a lawsuit against you as an investor or homeowner or owner of property, or you file a lawsuit against the association after attending pre-suit mediation, you want to be able to collect your attorney's fees. If you do not participate in the entire mediation process, and by that, the courts have said you must, the demand must be made on you as an owner or investor. You as an owner or investor must respond to the demand timely, that's within 20 days. You must agree on one of the proposed mediators that are provided in the demand letter to you. You must agree to share in the cost of mediation and pay the mediator's fee. Both parties share equally in that cost. And you must appear for the scheduled mediation. Last but not least, mediation must be completed within 90 days unless an agreement is reached between the parties to extend that date. So one of the same case that I just mentioned that's up on appeal, the issue is the association, prior to the 90-day period elapsing, made a demand on the client to participate in mediation. The client agreed. The client asked for an extension because they had some health issues. On the 48th day, the association decided that the client's request for an extension was a bad faith request, and they filed a lawsuit. And then they proceeded in the trial court to enforce the covenant restrictions, and they prevailed here's the problem. The problem is the argument of the homeowner investor is you didn't complete the entire pre-suit mediation process. So $75,000 later, the association may very well not collect on its fees because instead of waiting the 90 days, which is statutorily required, at least that's the position of the owner investor, they jump the gun. And so that issue is also up on appeal. But I mention that to say, if you get an invitation to participate in pre-suit mediation, then I definitely encourage you to do that. These lawsuits can be very, very expensive. They can be very time consuming. And if you don't participate in a good faith way in the mediation process, then you may or may not be entitled to recover your attorney's fees. The Condominium Act has a different provision that talks about alternative dispute resolution. And I'm focusing on these things because I think parties want to avail themselves of these mechanisms to the extent that they can, because it saves quite a lot of money at the end of the day. If you find yourself in a dispute as an investor, someone recently purchasing property, intending to fix it, flip it, there are things that you don't want to get bogged down in a lot of legal expenses. And if you can cut certain things off at the pass, then that benefits you, that benefits your bottom line. And lots of times, not all of the times, you can avoid a lawsuit being filed. The Condominium Act is different in that typically you're going to go to non-binding arbitration. There's a mechanism in the rules for the parties who cannot agree in the context of a condominium dispute to make a demand, file a petition for non-binding arbitration. And there is also built into that an option for the parties to participate in pre-suit mediation. But both the homeowners association, in the homeowners association context, the penalty for failing to complete the entire pre-suit mediation process is you are potentially not going to be able to recover, if you are the prevailing party, your attorney's fees and costs. It's a different scenario in the context of condominium associations. If you do not participate in pre-suit arbitration, then if you file a lawsuit, if you go straight to court, well, then the other party can seek to dismiss your lawsuit because that is a precondition to filing the suit. And so the penalty is not just you don't get to recover your attorney's fees. You actually can't proceed in court unless the other party waives their rights to resolve that issue without having gone to the pre-suit arbitration or mediation process. There are different things that can be mediated and arbitrated. I have done mediations and arbitrations related to association disputes, but most of the work that I do, I'm not required to attend mediation or arbitration because the disputes typically are about assessment. Whether or not as an investor who purchased property through foreclosure or some other mechanism, my client is responsible for paying the prior owner's delinquent assessments and related charges. Now, typically, if property is conveyed voluntarily, meaning you simply purchase the property through, a closing, you have a grantee and a grantor, you execute a deed, the property gets, transferred at closing, that's the normal case. Typically, in those situations, you are responsible as the new owner or investor for whatever the prior owner was responsible for. In the context of involuntary conveyances, such as foreclosure cases, that same proposition doesn't hold true. There are certain things that you are responsible for typically when acquiring title through foreclosure or an involuntary process, that you certain things that you're not responsible for and certain things that you are responsible for. Give me 1 second. Before I get there, I want to point out, I tried to touch on the things in preparing this presentation that you as investors will more commonly deal with. And this is why I'm sad that I can't share with you some of the, Alex, can you hear me?
Yes, we can hear you.
Okay. My phone rang. I was like, did I get cut off? And you're trying to reach me because I've been talking for 10 minutes. And no one knew. Before I get there, I want to touch on just a few other issues that I see come up commonly with investors and new owners. The estoppel certificate particularly is, and Alex, I'm sure you can speak to some of this, when you get to the point that you either want to purchase the property or sell the property, there's always a question about what amount must be paid to get an estoppel certificate. Well, that is statutory and contractual, and I'm just going to point that out to you as something to flag to make sure that you're not being charged more. If you currently own the property, you have a right to obtain a certificate certifying exactly how much are owed in maintenance fees, assessments, and related, when I say related charges, I mean interest, late fees, anything else that the association may be charging you. The association is not bound by that certificate and can update it. If you are someone other than the owner, well, a different set of rules apply. So if they issue a estoppel certificate to you as a purchaser, someone who intends to purchase the property, well, they are bound by that. So I'm just flagging for you that different rules may apply, and the amount that they can charge for the estoppel is also fixed in the statute. It's like $250 if the property is not in collections. If it's in collections, you can add an extra $150. And then at the end of the day, if you are the person intending to purchase the property and the closing doesn't go through, and I'm now wading into probably Alex's territory, there's a mechanism for you to request your money back. So just as investors who may be doing a lot of purchases and, these $250 estoppel costs start to add up, don't forget that there is a mechanism if the closing doesn't take place, the sale doesn't go through, for you to request the money that you paid for the estoppel certificate back, and that is built into the statute. Let me also quickly mention, the association has a right to charge a fee for an estoppel certificate so long as there's a provision made for charging a fee in the declaration. And that's one of the reasons we as attorneys who litigate and deal with association matters say the declaration is the Constitution, because the statute says, yes, you can charge $250, but if you keep reading, it says pretty much so long as there is a provision for charging a fee in the declaration. A lot of times I see attorneys are just automatically paying these fees. Investors, owners are automatically paying these fees, but no one ever took a look at the declaration to see if the declaration authorizes a fee to be charged for that. So just make sure as an owner, to the extent that you are being charged a fee for an estoppel certificate, that is permitted by the declaration, or at least authorized by the declaration. The other thing that I want to talk about briefly is something that I found to be very powerful in Florida statutes relating to associations. Once you become an owner in the association, you have certain rights, right? There's all these responsibilities, but you also have certain rights to request an estoppel certificate, and also rights to inspect or review records. And if after the association receives a request for records, right, you're trying to sell the property, you're trying to buy property, there's certain things that you may want to know, or things that you may need in order to complete the sale or to encourage the buyer to purchase. Well, you can request directly to your association the records that you need, and they have to give them to you. It's a written request within 10 days. And if they don't give them to you within 10 days, on the 11th day, there's a presumption that they acted in bad faith, and a $50 fine against the association, daily fine, begins to accrue. So just know that there are some tools that you have to get information that you may need as you're either purchasing property or selling property, and you want to avail yourself of not only the burdens of owning property in a community with an association, but also the benefits of that. Getting back to what I primarily do, which is assisting clients who are trying to close on property or purchase or acquiring type of property through foreclosure, trying to figure out what exactly do they owe the association. And I always get calls from title counsel or, you know, folks, even association property managers, and they automatically tell me, oh, well, the person who's acquiring title owes 1% of the mortgage or 12 months of the preceding unpaid assessments. And I always tell them, well, maybe, maybe not. And in most instances, and that would be actually for the first mortgagee. And the first mortgagee is typically speaking the bank. And I've had some litigation where a private investor holds a note, and you know there's a lot of back and forth because it's the definition of who a lender is very specific, and unless you're doing large scale lending and those types of things, it's tricky and arguable whether or not someone individual who's holding a note can avail themselves of certain provisions reserved for, you know, larger lenders and services, et cetera. But very long story short, if you purchase property through foreclosure, then you have certain rights and usually in a pretty good position to at most have to pay the prior owner's delinquent assessments, unpaid assessments, because the statute is fairly consistent. The homeowners association statute and condominium association statutes are very similar, but they do have some differences. So if you purchase a condominium through foreclosure as an investor, you typically have 30 days within which to pay any assessments or related charges that accrued by the prior owner if they are due and owing by you, which I would say 75% of the time they are not, right? At most, assessments are due and owing. It is unusual if assessments, late fees, attorney's fees, interest, and all the rest of that stuff is due and owing if you are acquiring title through foreclosure. People say, well, how do you know that? Why do you know that? Because the declaration will tell you that. And there's some very powerful language in many of these declarations, which we sort of in this area of law refer to as subordination of lien language. And believe it or not, many, many times associations, in order to encourage investment in these communities, have agreed to subordinate their lien for assessment, interest, late fees, all these other fines and things, if a property is acquired through foreclosure. Because the idea being they want to go ahead and get these units filled as quickly as possible. But another nice thing about the Condominium Act is you have 30 days to figure it out in terms of what you have to pay and what you do not have to pay. Homeowners Association statute doesn't provide for that 30-day grace period. And so I tell my clients, you always want to pay if you're acquiring title to property through foreclosure or through an involuntary conveyance, you always want to pay what you know you owe. And what you know you owe is assessments that begin from the date that you acquired title to the property. You're going to have to pay those assessments for sure. And then you figure out relatively quickly And some of this legwork you can do as investors before you purchase the property. You can look at the declaration to see, is there, and when I say you, my clients hire an attorney to do this because it can get very complicated, but you want to look to see, is that subordination of lien language in the declaration? And if it is, have there been any amendments revising that language? And if there hasn't been, and I can tell you, I've saved my clients, I mean, just assume the issue is you do owe the delinquent assessments. Let's just, for argument's sake, the client does owe that. The declaration says you owe that, and then the statute says you owe that. Well, attorney's fees can be thousands of dollars. And so when I get these cases, you know, the first thing I'm looking to see is, what does the declaration say? How does it define assessments? Are attorney's fees, interest, late fees, and other charges included? Certified mail fees, I mean, they tack on everything, recording fees, things that they haven't even done yet. You know, are those a part of the assessments? Assessments are typically a reference to things that are paid to support the common elements. It's not attorney's fees and all of these other things. So in most instances, my clients don't owe everything that the association is demanding. In many instances, my client doesn't owe anything. And so we push back, and we push back effectively to say, look, we're going to pay what we owe, but we're not going to pay a penny more than we owe. And, you know, interestingly enough, associations represented by counsel typically will acknowledge that they're wrong, because what they're doing is they're automatically sending out these demands in hopes that people are not savvy enough. And I'll tell you, even as attorneys, oftentimes one of my longest standing clients came from an attorney who was trying to close a deal at closing and resolve the issue and couldn't get it resolved, and didn't realize, you know, they were trying to offer a settlement amount when in fact the client owed nothing to the association. And I ended up suing the association. The association's insurance carrier immediately got involved, waved the white flag. My client got all of the money back, because oftentimes when you're dealing with associations, they will not budge because they know they have you. When you're at the closing table, you're trying to close. But here's the thing. If you pay money that you do not owe, then those of us in this industry can get that money back. If you paid money you did not owe the association, then we can get that money back for you. There is a 5-year statute of limitations for breach of contract. The declarations are contracts. And so, you know, my job, when I started out as an attorney, I was a criminal prosecutor. And I always felt very good about the work that I was doing. And in this instance, as someone who is very passionate about association law, I really feel as though I am providing a service to the community, really, by making sure that the associations follow the rules. They play by the rules, that they don't receive things that they're not entitled to receive, that they're not killing the new owners and investors who are trying to get these properties back on the market, right? Trying to fix these properties up to make sure they're not being forced and coerced into paying monies that they absolutely do not owe. And at the end of the day, what I do is hold their feet to the fire to make sure that my clients only pay what they actually owe to the association. And typically, when a client purchases a property, and all of these assessments and interest and attorney's fees are not required to be paid by my client individually, solely and individually, they become a part of the common assessments, and they just get put back into the community and spread amongst the community. And everybody then has to bear some responsibility for that, but it doesn't fall on the one unfortunate person or investor who tried, you know, to help in getting this property back on the market, or at least a tenant in the property, so that it continues to be, you know, a part of the community and generate the revenues to ensure that everyone within the community can continue to live based on the rules and the regulations. So I have a few more minutes. I'm going to stop now. I could talk about this literally all day. It is sort of my passion in the law, but I want to find out if anyone has any questions and take a few questions. I can certainly talk until about 10 minutes after 1, but after that, I'm going to have to jump off the call.
Okay, Attorney Maroun, David Pollack has a question for you.
Wendy, that was great. My question
Thank
is,
you.
I bought, and this is real life. I bought a property and I couldn't sell it for a couple different reasons, but there is an assessment coming and it's not there yet. So I'm quit claiming my property to somebody else. Does that absolve me from having to worry about the money that they're going to try and collect from the next owner, or am I going to be held liable?
Well, no, if you deed the property before the assessment is imposed, then you're not liable for that. However, and Alex, you may be better able to speak to this, typically those things are disclosed, right? Any major assessments that are coming down the pike are usually disclosed through the closing process. So Alex, what has been your experience with that? I know someone who recently was about to purchase property and there was a significant assessment that was about to be imposed, and that was disclosed because the lender also wants to know.
Right, so David, you wouldn't have any liability for an assessment that has not yet been levied. But yes, that will be disclosed in advance before it's been levied so that the buyer is not blindsided, but that is not your obligation. And in fact, even if you quitclaimed a property that had unpaid assessments, they're not going to come after you for it. The liability is always going to travel with the unit to whoever owns it.
Thank you
In
very
my
much.
line of work though, yeah, just so you know, that's true, but I just want to provide a small caveat. So the Condominium Act and the Homeowners Association Act creates joint and several liability. If you purchase property through foreclosure and you acquire title of that property and you have to pay assessments or some other charges, you can go after the prior owner to get your money back. It doesn't happen often, but you can go after the prior owner if you end up as the investor or new owner and paying off some of these liabilities that were incurred prior to your ownership to the association.
That is good to know. Attorney Maroun, when you order the condo estoppel letter, is there a time limit for them to provide you the information?
Let me check the statute. That comes up, I want to say, more frequently in the transactional side of this.
Yes.
Let me see what I put in my, give me 1 second.
Right, he's asking.
And I do the litigation side of this, but I have one of the statutes here. Let me just take a look here. If there's a deadline, it's 10 business days. And in fact, there's a penalty if you don't deliver in 10 business days. If an association receives a request for an estoppel certificate from a unit owner or the unit owner's designee and fails to deliver the estoppel certificate within 10 business days, a fee may not be charged for the preparation and delivery of that estoppel certificate. And that's a part of the Condominium Act.
That does come up a lot.
Yep, so they have 10 days. If they don't get it to you in 10 days, then when they ask you for the fee, you tell them to kick rocks because you're supposed to get it in 10 days.
Wendy, is there any difference in the laws regarding a co-op rather than a regular condo?
Those are regulated by a different statute. They're not a part of the Condominium Act. Hold on, let me just make sure before I say that. I have not dealt with any cooperatives. I'll tell you, the Department of Business and Professional Regulations, they handle condominiums, cooperatives, and all those other things. But let me just double check, because that's sort of outside of my, outside of what I typically do. Give me 1 second, let me check. While I'm checking that, does anyone have any other questions?
You were touching on the effect of a foreclosure. My understanding is that the 1% or 1 year only applies to institutional lenders. So if
Correct.
indicating if it was a private note or even a hard money loan,
Right.
that the hard money lender,
You usually don't get that benefit. Can you hear me?
yes, we're hearing you when we're
Oh, okay.
all nodding, because quite often it could be, and also does that limitation apply to a second mortgage or only a purchase money first?
Does the 1% of the mortgage? Well, here's the thing. If the one, you're not going to find many instances. I used to do a lot of foreclosure work. You're not going to find many instances where the second mortgagee is foreclosing and the second mortgagee gets foreclosed out, right? So you have the first mortgagee, which has the senior lien, if you will, in the property. They just foreclose out the second.
Well, a few of us have run across a foreclosure of the second.
You mean the second forecloses? It's like a homeowners association foreclosing. People can do it, but you don't really see that often because the bank has the first mortgagee has the senior lien, and everyone for the most part is going to get wiped out once the bank forecloses, right? If you're not, I mean, sometimes I guess people don't pay their second, but they continue to pay their first and their association dues. But when people start letting go of making payments, everybody tends to stop getting paid. So I can certainly check on that. You're asking what, well, if the bank I mean, look, it's the provision, and let me just take a look at the statute. It says the liability of a first mortgagee or its successor or assignees. I believe that's a reference to whoever has the senior lien.
Yeah.
But don't hold me on that. And the senior lien holder would be, you know, the bank that's in first, what we would say first position. A purchase money mortgage that is in first position. And by that, I mean who has the senior lien rights against the property. That's probably a more technical explanation.
Yeah, so Wendy, another situation that comes up is if the investor purchases the property at a tax deed auction, what, if any, assessments, attorney's fees, or penalties survive the tax deed foreclosure?
I don't know the rules on tax deed foreclosures. I believe, and I'm speaking very generally, so don't hold me on this, and I probably should have put my disclaimer out at the very beginning. I am giving information for informational purposes only. I am not providing legal advice or counsel. Every situation is different, and you really do need to speak individually with an attorney if you have any specific legal issues that need to be addressed. But for purposes of this meeting, I am trying to give general information based on general scenarios that may or may not exist. I don't deal with investors. My personal experience has not been with investors who acquire title to property through tax deed sales. From what I understand, the tax deed sale is pretty powerful tool and pretty much eliminates everything. And, you know, to the extent that it doesn't, again, it would be subject, to the extent that it doesn't wipe out everything, you know, assessments, attorney's fees, et cetera, then you would look to the declaration to in the statute for tax deed sales to see what, if anything, could be collected after the tax deed sale.
Thank you. Does anyone else have any questions?
You're welcome.
As we get towards our expiration point? No? Addison? All right, well, thank you very much.